Hello everybody and welcome to a new video. Today we are going to be talking about a very intriguing topic, admissibility of WhatsApp chats in Indian courts. Yes, this is a legal topic and going forward we are going to see much more legal content, whether it is based on new legal developments, specific frameworks in law, you name it, and we will have the content going forward. So do stay tuned for that, and I do hope that you like the insights which we share there. Anyways, coming back to today's video, we are going to be talking about admissibility of WhatsApp chats in Indian courts. Now, owing to the development in the last couple of decades, electronics have changed the face of communication. It has taken over important conversations like business dealings, establishment of contracts, and other important activities too. And with it comes the legal intricacies and consequent discussions of amendments and additions of regulations for the realm of online communication, which is replacing the redundant pen and paper method. And this used to be the relevant form of communication when law and major evidence acts were actually formulated in the previous years. Moving forward, the current laws that took over the area include the Information Technology Act 2000. This was passed by the Indian Parliament and that added Section 65A and 65B to the Evidence Act 1872. This set new guidelines for the admissibility of electronic evidence before the courts of law. The Information Technology Act 2000, in specifically the Section 2T, defines electronic record as data, record or data generated, image or sound stored, and image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfiche. Subsequently, Section 3 of the Evidence Act also legitimizes the use of electronic records as evidence before the courts of law. The interpretation of these definitions holds key importance in understanding the legal aspects of the admissibility of electronic records as evidence. Section 65A and Section 65B of the Evidence Act draw the necessary conditions of the admissibility of electronic records. Section 65B2 specifically highlights the four essential conditions for computer output to be admissible in evidence before the courts. The four essential conditions are as follows. The device in question from which the data has been furnished must be in continuous use over the given period of time by the person having lawful authority over it. The second point, the concerned information during the specified time must be ordinary in the activities that were being carried out. The third point, the computer must have been functioning properly during the time period in question. In case the computer was having some technical deficits, it must be appropriately indicated that such malfunction did not impact the information being produced before the court. And fourth one, the data from the computer must be reproduced as it was in the original device. Section 65B1 of the Evidence Act mentions that any evidence contained in an electronic record that might be presented in printed, stored, recorded or copied onto optical or magnetic media devices by a computer shall be considered a document. And if such information fulfills the conditions mentioned in Section 65 of the Evidence Act, it shall be admissible in the court of law without further proof or production of the original device. Now, coming to WhatsApp specifically. Due to WhatsApp chats being a significant part of the investigation in several high-profile cases, which were religiously covered by the media recently, a lot of us would be curious as to how our personal chats may be used in investigation, and does the law really have provisions for that? So, WhatsApp chats fall under the definition of electronic records as defined under Section 2T of the Indian Evidence Act 2000. As electronic records, their admissibility as evidence before courts of law would be governed by Section 65A and Section 65B of the Evidence Act. WhatsApp chats have been admissible in courts mostly as secondary evidence, as they are often produced in the form of printouts. Now, the four requisites mentioned under Section 65B2 have to be fulfilled when submitting WhatsApp chats as evidence. Thus, for WhatsApp chats to be admissible as evidence in Indian courts, the following conditions must be fulfilled. The recipient must have received the messages signified by double blue ticks in WhatsApp. Number 2, the device must be in regular use and must not be damaged. And number 3, the messages must be sent intentionally by the sender. The major challenges posed while advocating electronic records like WhatsApp chats as evidence before the courts is due to the complex technicalities of such platforms. Features like the ability to delete text once sent raises questions regarding the reliability of such records too. In order to address these concerns, the courts are empowered to seek expert opinion under Section 45 of the Evidence Act for technical matters. WhatsApp chats have been admitted as evidence in courts of law and have mostly been utilized as secondary evidence subject to the fulfillment of the conditions under Section 65B2 of the Indian Evidence Act. Now, coming to some case laws, the courts have held in various judgments that WhatsApp texts have been forwarded numerous times and that the source of information, which is unknown, and when neither the original nor the copy of the original can be furnished before the courts, such records cannot be admissible as evidence. And this was held in the case of Girwar Singh versus CBI. It has also laid out that when the rest of the communication has occurred over WhatsApp and that the fundamental principles of a contract are actually being fulfilled, contracts arrived at over WhatsApps can be held to be a valid and enforceable oral contract. And this was held in the case of Shamsuddin bin Muhammad Yusuf versus Suhaila binti Suleiman. Further, it has been also clarified that if a computer system was malfunctioning, the information obtained from it cannot be admissible as evidence in our courts. And this was found in the case of Sri P. Padmanabh versus Syndicate Bank Limited. And finally, the significance of blue ticks has also been highlighted quite critically in these judgments, wherein the blue ticks were considered legitimate proof with regard to the recipient having received and read the message. And this was held in the case of SBI Cards and Installment Administrations Private Limited versus Rohit Jadhav. So, I hope that you guys did like the insights which you have shared regarding this very important topic, as it is very much relevant to us in our daily lives. And if you did like the insights, please do like, share, subscribe, and even comment on this video to let us know your thoughts regarding this topic and whether the court should actually hold WhatsApp text legitimate and admissible in Indian courts. Also, for your information, we are also be putting the case links, all the case laws which have been mentioned, their links in the description box below, so you can check them out for a reference. Anyways, till next time, thank you for watching and do stay safe.